Some have spoken of the new constitution as representing the second independence. And this is when our institutions and the people are to come into their own. When the legislature will truly act as the representatives of the people and the supervisors of the executive. When the executive will put the interests of the nation first above the interests of tribe, individual, and class. And when the curse of impunity will be ended and the rule of law prevails. This will only happen if we all, including the judiciary, play our part, for the forces of resistance are strong. By the rule of law, I do not mean the sort of mechanical jurisprudence we saw in cases like the Kapenguria trials. It was mechanical jurisprudence that led the High Court to reach an apparently technically sound decision that the election of a sitting president would not be challenged because the opponent had not achieved the pragmatically impossible task of serving the sitting president in person. It was mechanical jurisprudence that fueled the decision of a High Court that the former section of the old constitution on the enforcement of bill of rights was inoperative because the Chief Justice actually hadn't drawn the rules for its implementation. And Chief Justice Miller basically confirmed that decision, although he should have drawn the rules. I see the Constitution, especially Article 159, a mandate for us to carry out reforms tailored to Kenyans' needs and aimed at doing away with these inefficiencies and injustices. It is perhaps remarkable that although disappointment with the judiciary was at least as great among the wananchi as frustration with politicians, it is also true that the Kenyan people chose to place their faith in the institution of the new judiciary in implementing the new constitution. And you know what, the way they did that was to make sure that judges are subjected to vetting and the new ones also subjected to vetting. But I want to emphasize here the need to develop new, not only highly competent, but also indigenous jurisprudence. I link this last objective to the Constitution's value of patriotism. Patriotism requires putting love of country above love of self. And for a judge and an advocate, it does not mean putting the country above justice. I conceive that it requires the judge to develop the law in a way that responds to the needs of the people and to the national interest. I call this patriotic and indigenous jurisprudence. Above all, it requires a commitment to the Constitution and the achievements of its values and vision, which is what comes on what I was talking about, Article 10, Article 6, and if you go through the Constitution, the values are littered all over the Constitution. And that's the vision, and those are the values that will change this nation. Now, few people now maintain the myth that judges in the common law system do not make the law. Our Constitution tears away the last shreds of that perhaps comforting illusion, especially in the context of human rights, when it says that a court shall develop the law to the extent that it does not give effect to a right of fundamental freedom. I understand some people, even lawyers, have found this obscure. As I read it, it means that if an existing rule of common law does not adequately comply with the Bill of Rights, the court has the obligation to develop that rule so that it does comply. And it's marked in Article 20, which follows, by an obligation to interpret the statute in a way that also complies with the Bill of Rights. This is an obligation not to rewrite a statute, but to read it in in a way that the Bill of Rights, the way that is Bill of Rights compliant, if at all possible. The Constitution must be a frame of reference for every lawyer and every judge, not just those who find themselves sitting in the Constitutional and the Human Rights Division or in criminal trial, but all those who deal with company law, land, commercial transactions, negligence, labor law, etc. And again, the Constitution makes this clear, that national values bind all of us, not only when we apply or interpret the Constitution itself, but when we apply or interpret any law. And those values which Council Mutunga has articulated include, of course, the rule of law, but also human dignity, equity, equality, social justice, non-discrimination, protection of the marginalized, integrity, transparency, and accountability. And any law would include, in my view, unless and until Council convinces me otherwise, rules of the common law as well as statutes. Now, I wanted to say that by patriotic and indigenous, I do not mean insular and inward-looking. The values of the Kenyan constitutions are anything but. We can and should learn from other countries. My concern when I emphasize indigenous is simply that we should grow our jurisprudence out of our own needs without unthinking deference to that of other jurisdictions and courts, however distinguished. Okay, we quote these cases from Australia, from other places, and we need to interrogate those decisions. And indeed, the quality of our robust indigenous and patriotic jurisprudence should be a product for export to these distinguished jurisdictions. After all, our Constitution is the most progressive in the world, and we should make the world a better place by exporting our quality jurisprudence to the rest of the world. Now, this task involves a partnership between the judiciary, the profession, and scholars. I hope that the bar too will respond to the challenge. The standards of advocacy need to improve. The overall quality of written and oral submissions needs to improve. At the judiciary, we are encouraging more detailed written submissions. This makes sense only if judges read the written submissions in advance and do so with a critical eye, prepared to interrogate the arguments of counsel, and prepared also to put forward alternative ideas. We are trying to make this task easier for you by enhancing the quality and quantity of legal materials available to the bench and by appointing legal researchers. You all know that every judge now will have a legal researcher. It will be a learning experience for judges as well as legal researchers to work out how the cause of justice can best be served by this innovation. Different judges will no doubt use researchers in different ways. Different researchers will have different skills, but we are confident that this offers an opportunity to make major strides in the quality of the jurisprudence in the courts of Kenya. I want to add that these major strides in the quality of jurisprudence in our courts will be amplified if judges improved collegiality and ability to co-educate each other so that the decisions coming out of the court will reflect collective intellect of the judiciary distilled through the common law method as well as through regular discourses and learning by judicial officers. And we think that to be a good judge must involve continuous training. Judges used to say they didn't know who would train them, but now they have accepted that they can be trained, and learning and regular informal discourses among judges. The Judiciary Training Institute must become our institutional higher learning and the nerve center of this emerging progressive jurisprudence. JTI will coordinate our academic networks, our networks with progressive jurisdictions, our training by scholars and judges, starting with our own great scholars and judges. In our training to breathe life into our constitution, our jurisprudence cannot be Anglocentric. It must place a critical emphasis on multidisciplinary approaches and expertise. We always say that we are learned, but we should be students of economics, political science, and other disciplines, because the Constitution requires us to be broader in our knowledge. So we should actually think very seriously about dropping the nonsense of learning, because invariably it shows our ignorance of other disciplines. Let us hope that the community of scholars responds to the challenge equally. The quality and the quantity of Kenyan legal literature is disappointing. We need high-quality commentary on the Constitution and our laws, and we need high-quality commentary on our judgments. We must not be sensitive to criticism. No one learns anything if they are not criticized. I hope that the courts of Kenya will truly be viewed as courts of all Kenyans, and the salvation of the Kenyan oppressed and bewildered. And to return to where I really began, I believe we shall only do this through the rigorous but creative use of the basic values of our Constitution, indeed through the judiciary becoming the embodiment of those values, especially patriotism, social justice, and integrity. I hope through this speech I've managed to spark constructive debate among all of us about our ground norm, the ultimate binding instrument and the covenant that Kenyans have inscribed their social contract with the state and with each other, which we are called on not only to interpret, but to fulfill and bring life. The last thing I wanted to say, which I should have said from the beginning, there are two of you, you all